Welcome to Legal Literacy series. This is my fourth presentation in this series. In my fourth presentation, I am concentrating on the role of witness in criminal law trial. And this presentation is the second part. In the first part, I concentrated on Indian Penal Code. Presently, I am dealing with Criminal Procedure Code. And for the purpose of clarity and ease, I have divided the presentation into two parts. Criminal Procedure Code, this is investigation, and next part is going to be Criminal Procedure Code trial. Criminal Procedure Code is a law designed elaborately to create a procedure by which the criminal is identified and punished. It's more of a procedure in nature, and in this procedure officially police and prosecution is duty bound to establish the crime and get the punishment for the criminal, but unofficially the duty is on the society. Police and the prosecution cannot function in vacuum. They need the assistance of society, and the society plays its role in the form of a witness, and many times it as a cooperative victim. When you look into the role of the society, we can broadly divide them into three. Following the cue from the earlier presentation, I am calling the alert citizen as Jago, and here the Jago's role can be to avoid a crime, and avoiding crime can be by informing police, or it can be even including arresting the person committing the crime. Secondly, he can also be a witness of a crime and cooperate with the prosecution and the police in getting the culprit convicted. And Jago can be a professional, and as a professional person in his professional capacity, he can assist the prosecution and the police. Role of witness during investigation is going to be discussed in the following manner. First, let us look into assisting of police. As I mentioned, duty to inform is one of the greatest assistance which a public can exhibit in justice delivery system. We can go one step ahead. Not only inform the police, we can arrest the person and wait for the arrival of the police and hand over him to the police. In case there is a violation of peace or breach of peace, take the example of COVID-19, spreading misinformation, communal hatred, these are nothing but an attempt to breach the peace, and any information available, if it is given to police, that would be assisting the police. Preventing injury to public property, this happens during agitations, in unrest, civil unrest, where there is a strike going on, and there again we can do our duty as a Jago. Not only arresting a person, we can also involve ourselves in preventing the escape of the criminal arrested by police. And last but not the least, the execution of warrant. A warrant is a document which is issued against a person who is not cooperating with the court or police. So in this situation, police can reach to your locality with the piece of paper, name written on it, but it cannot identify the person. So you can help in identifying him and assist in justice delivery system. So coming to information to police. So when the offences are broadly divided into cognizable and non-cognizable offence, And when Jago comes to police station to inform an offense, if it is categorized cognizable, process is different, and non-cognizable, process is entirely different. So let us look into the process first, and later I'll classify the difference between cognizable and non-cognizable. Once Jagu reaches police station, he is asked to narrate the incident to officer in charge of the station. The information can be given in two ways: either you bring it in writing, or you can come and explain it orally, where the officer in charge will write down the complaint. If you follow the second system, that is a written complaint, then after writing the incident, the whole thing is read over to the Jago, just to confirm the story that has been given to the police. Once reading over is done, then comes the stage of signing the report. So this information given by Jago has to be signed by the Jago for the purpose of future activities. Once the information is written, signed, then the same information is added into the station diary for further documentary evidence. And most importantly, at free of cost, a copy of this information is given to Jago, signed by the state officer in charge, bearing the complaint number. This whole process is mandatory if the information is about cognizable offense. The cognizable offense, so let us add few more complications into this whole process. Refusal to register. Now this is one most common problem, common question which every person poses in their mind. If our information or the complaint is refused by the police, then what to do? I have made a separate presentation on this, and I will give you the link in this same presentation, where the remedies against the refusal to register. But as far as criminal procedure is concerned, there they provide one remedy, that is post the complaint to the superintendent of police in the locality. He would take the necessary steps and ensure investigation of the crime. If the victim is crime, see, information is given by two kinds of people: one who has witnessed the crime and another who has suffered the crime, that is the victim. And if the victim happens to be a woman and she has suffered a sexual offense against her, then the whole process differs. We have divided women into two categories. One, a woman who has suffered mental and physical disablement. Such lady need not come to police station. The information is recorded at her home to provide relief and peace of mind to her. She has already suffered double disadvantage: one, physical and mental disadvantage, and then a sexual harassment or an offense against her. So not to harass her further, the facility is provided that a lady officer will go to the home and record the complaint. And second facility is videographing. The whole complaint or whole narration of this lady is videographed, so that the police can refer to videograph rather than troubling her again and again. On the other case, if the woman victim is other woman other than mentally and physically disabled person, then the facility is the interview. The information is collected by woman police only. And finally, in all the cases of sexual harassment against a woman, the reported or the information is given to judicial magistrate as soon as possible. In case of non-cognizable offense, the information is given in the police station. There is no distinction between woman and man here. Everybody has to come to police station and give the information, and the information is forwarded to magistrate, the judicial magistrate. The purpose is to seek permission to investigate. So the cognizable. So the major difference between cognizable and non-cognizable offense is rights of the police. Here the police enjoy right to investigate and right to arrest. but whereas both rights are absent in case of non-cognizable offences. Then the question that comes to our mind is, when I am coming to police station, whether to give an information or report a crime, whether I am reporting cognizable offence or non-cognizable offence. The distinction is given in this act, that is the Criminal Procedure Code. There is a big schedule, and in the schedule they have classified cognizable and non-cognizable, bailable and non-bailable offences. So you have to go through the list to find out which one it falls under. The major way of distinction and simpler way of distinction is serious offence and non-serious offences. So the best way to deal with this is ask the police officer, use these technical terms, and usage of these technical terms alert the police officer and not to play with the informant. At the same time, if you are associated with an advocate, it would be even better. So, professional assistance in the criminal investigation and trial. A doctor can be a very important assisting force in a criminal trial. So, there is a need for a medical examination in case of physical assault. So, doctor may be expected to examine medically accused person, arrested person as well as victim. So, police may approach any doctor, and doctor must volunteer to do that, and once he does that, he has to prepare a report and appear as a witness during investigation as well as trial. So once the case is registered, an investigation is conducted. During investigation, police may find the need to examine the witness. So there, the witness should be called to the police station for examination. And here there are certain rights the witnesses enjoy. First and foremost, very important, witness will need to answer every question that is being put to him by the police. But if any question incriminate the witness or any criminal charge could be framed against him, so if answer is given by the witness and that would create another criminal trial against the witness, then he need not answer those questions. He can stay quiet. This question answers would be recorded in writing, brought down into writing for the purpose of investigation. In case of woman victim, there is only woman police officer who is going to conduct this investigation. Once the recording is done, these are the following important rights. Witness has the right not to be induced. So police cannot use any of the inducement technique to get the information. If at all they do it, sincerely I suggest you to bring it to the notice of the judiciary or the judge at the time of the trial. No signatures. Recorded information, anything is there, any document is there, the witness should not sign it, need not sign it. Except the first information of a crime, none of the documents need to be signed. And very important, the information given in the police station has no evidentiary value in the whole trial. So this is only for the purpose of investigation and not for the purpose of trial. The last and the most important power of the police during the investigation is power to search, and here they can search the house of the witness, victim as well as the offender. If the police finds that there is an important evidence and which needs to be collected without causing any delay, evidence may be a document or maybe any other weapon used in the offense, etc., etc. So here the key is without causing delay. So he cannot go to court, ask for a permission. In such situation, police is given a power to record the reasons of this search in writing, list out the things that he is planning to do the search, and then place where he is going to conduct the search, and as far as possible it is suggested to search in person instead of sending any other person. So these are the important rights, duties of witness in investigation stage. I'll come up with another video where rights and duties of the witness at trial stage would be explained. Thank you very much.